good to see so many people in person today. I haven't seen some of you except on WebEx for a while. We have three bill hearings today. Two of them we're going to do together. Oh, yes.
Thank you, Mr. Chairman. If I could just have a point of personal privilege, we just all want to wish you a very happy birthday.
Oh, thank you. Thank you.
Ready? Happy birthday to you. Happy birthday to you. Happy birthday, dear Chairman. Happy birthday to you.
But thank you all. I actually keep forgetting it's my birthday. So when things like happen like that, it kind of surprises me.
Mr. Chairman,
thank you.
as you can see, that's why I'm decided to attend today. So,
well, good to see you all. And thanks for the birthday greetings. Okay, let's get started. I'm going to open the hearing on and we're sent here for us to just take a quick look at, see if there's anything that needed to be tweaked. So they've already had hearings, but we're going to give them hearings again today. I suspect maybe when they had, I've not looked, but when they had original hearings, there may have been more conferee. So I do encourage you to go back and look at that, and I will do the same. So let's get started. House Bill 2674. We'll open that hearing and we'll have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2674 requires a forfeiture of an appearance bond to be set aside in certain circumstances. The bill amends KSA 222807. That's the statute that provides for forfeiture of bail and an appearance bond. Current law there in subsection A provides that if a defendant fails to appear, then the court shall declare a forfeiture of the bail. This bill would add a provision that would require the court to issue a warrant for the defendant's arrest when that defendant fails to appear. Current law also further down in that section provides that when a bond has been forfeited and a surety can prove that a defendant is incarcerated somewhere within the United States prior to judgment of default, then the court would set aside that forfeiture. This bill would add that the forfeiture shall be set aside if the warrant that's now required to be issued under subsection A is not issued within 14 days of forfeiture. The surety made a written request to the court to order the sheriff to enter the warrant into the National Crime Information Center's index, and the warrant was not entered within 14 days unless good cause is shown for the failure to timely enter that warrant. Or 3, the defendant has been arrested outside of this state and the prosecuting attorney has declined to proceed with extradition in that case. This bill was heard and worked in House Corrections. You'll see over on page 2, the changes that were made to that second instance where the surety makes that written request for the warrant to be entered into the index. As originally drafted, it would have been a written request to the sheriff, but as amended by House Corrections, that request is that the court order the sheriff to enter that. And so if you have any specific questions about those changes, I can answer those. But
okay, do we have any questions for Natalie? Okay, thank you, Natalie. We'll start with proponents, and I have one listed, Shane Rolfe, and Shane is on WebEx.
Thank you, Mr. Chairman. I don't know. I did submit. I'm sorry. Let me back up here. I'm Shane Rolfe. I'm the Vice President of the Kansas Bail Agents Association. We submitted testimony on this and testified at this in the Corrections Committee. So I don't know that you necessarily want me to go through the full gamut of all the testimony I gave there, but I can give you like a brief rundown of what we were hoping to accomplish with the bill so that the members of this committee who are not on corrections can kind of get some semblance of what we were trying to accomplish with this. Basically, there are some jurisdictions, not many, but a few, that are prioritizing pursuing the bond forfeiture money over actually pursuing the defendant, or at least they're focusing on getting the money first before they're working on trying to catch the defendant. They're doing this in 3 different ways. One is they're refusing to issue the warrant until after they've already filed a motion for judgment on bond and the time periods in the statute have passed to collect that bond before the prosecutor or the state is actually issuing a warrant to try and get that person back. The second one is, as noted here, refusing to extradite the person when they're actually captured out of state. And the third one is refusing to even entertain the possibility of extradition by refusing to place the warrant into the NCIC system. Essentially, and my original testimony went into a lot of reasons why this was bad and why that needed to change, and some of the reasons why the bonding companies need to have an active warrant, particularly when we're going into third-party states. Well, third party is probably not the right language, but into other states where there's a requirement in their law that there be an active warrant in order for the bondsman to pick them up. And that warrant needs to be accessible in NCIC for us to have the authority to pick them up in that other state. So we think that the changes that are being proposed here will correct these problems and will then will require the state to actually also attempt to capture the individuals missing, as well as us attempting to capture the individual. If the state's unwilling to do that, then they shouldn't be able to also try and then collect the bond forfeiture in lieu of getting the person back. They should be attempting to get the person back while also trying to enforce the bond forfeiture. And I can answer any questions about, this that anybody might have. If I don't want to go into the full, 25 minutes that I spoke last time.
Very good. Committee, any questions? Representative Carmichael. Oh, hold on one second. Shane, one question from me. So there's been some discussion as to whether we want this to apply just to felonies or misdemeanors as well. Do you have an opinion on that?
Partially both. I think the issuance of the warrant needs to be global. It needs to apply to every single case, whether it's a felony or misdemeanor. The court or the state still needs to issue that warrant for that person. On the extradition, it wasn't really addressed, but I think it can probably be limited to felonies. So I know there's some proposed language to fix this up here, but I would just want to make sure that there's still a requirement that warrant be issued in every case, but NCIC or extradition would only be required in felony cases.
Representative Carmichael.
Thank you, Mr. Chairman. Mr. Rolfe, so am I understanding you to say that in misdemeanor cases, you may not be strongly advocating that these warrants have to be entered in NCIC, or do I misunderstand?
I don't want to get a situation, Representative, where the bonding companies are able to take traffic warrants and say, hey, you didn't extradite this guy, so we should be off the hook. So yeah, we are simply advocating this for felonies more over misdemeanors. I know that misdemeanors can be extradited, but that is generally not the standard practice. So we would not be requesting that.
Mr. Chair, with your permission, though, the thrust of my question is the entry of misdemeanor warrants into NCIC.
It would probably be helpful. It just depends on if you have to go out of state, that warrant needs to be there. But some of the states I referenced in my last testimony that we discussed, like California and Texas, if it's not extraditable, it's not really going to give us any benefit, because in those states, we would actually have to pick the person up in, say, California, turn them over to local law enforcement for extradition purposes, as opposed to us removing them from the state. And there's about 16 or 17 other states that require that similar procedure. Again, I don't want to be in a position where we're, having people trying to get off bonds on traffic instances or low-level misdemeanors, that have fled the area. But on felonies, I think it's appropriate. I don't know that we would be requesting that misdemeanors be entered into NCIC, though.
Thank you for your help, and thank you, Mr. Chair.
Any other questions? Okay, thank you. Any other proponents? We have one neutral. Ed's hiding over there. Ed Klump. Like, I know he's here somewhere.
Thank you, Mr. Chairman, committee members. My name is Ed Klump, and I'm here today representing just the Kansas Sheriff's Association. So it's easier to say. Mr. Chairman, we want to make clear we're not taking a position. That's the reason we're neutral. We're not taking a position on the base of this about the forgiveness of the bond. That's a matter that doesn't directly affect us. But what does affect us is the procedural things that are in this bill about the entry into NCIC. And so primarily the things we're looking at are on page 1, lines 34 through page 2, line 6. And one of the things already been addressed in your questions, felony versus misdemeanor, we would prefer it just to be with the felony. And I can kind of explain part of the issues with NCIC entries on misdemeanors. One is there's a lot more misdemeanor warrants than there are felony warrants, obviously. And we pretty much all try to get the felony warrants into NCIC with a few exceptions. But on the misdemeanors, when we enter a warrant, we have to enter where we would extradite that person from. And that's not just across state lines, but even within the state. For example, we might say that we will extradite the person only from an adjoining county. Some we may say we'll, extradite that person anywhere from Northeast Kansas. And some will say statewide, and some would say anywhere. It kind of depends on what the situation is and the level of the misdemeanor. So given that information, for example, if we say we're only going to extradite from an adjoining county, I don't think that's going to be helpful to this situation, because when Missouri or California or whoever sees that entry, they're going to say, we're not extraditing from your location anyway. So we don't think that's particularly helpful. On the converse, when we're talking about felony failure to appear, we think that is very reasonable to have us enter those. We have no objection to doing that. Our preference, for a couple of reasons, is that not be by court order. One, we don't feel like we need a court order to do our job. We hope we don't. But secondly, it's consistent with two other places in statutes where we are required to make NCIC entries. And in those cases, it's a statutory requirement that we make them within a certain time limit. And so changing that would be consistent with this. That's not a hard line thing for us. If there's some reason that you all believe the court order process is better, then, we can certainly live with that. But we think the other is more workable for us and more understandable for us, and at the same time doesn't create another action by the court to make that entry. And, within a statute, it's going to be, we have a felony warrant for failure to appear, entered in NCIC. That's what statute says. That's what we'll do. If it's a court order, you could have people say, well, we didn't get a court order on it, so, or we missed the court order or whatever. And so we just think that's clear. And with that, Mr. Chairman, I'll stand for questions.
Questions? Okay, thank you. Any other neutral conferees? Any opponents? Seeing none, close the hearing on House Bill 2674. We'll move on. I'm going to open the hearings on House Bill 2582 and Senate Bill 425 at the same time. And we'll have Natalie review those and any differences between the two.
Thank you, Mr. Chairman. House Bill 2582 and Senate Bill 425 are identical. They were identical when they were introduced, and the same amendments were made to both of them in committee. So I'll just talk about 2582, but just know that everything that happened in this bill also happened in Senate Bill 425. So the bill amends multiple statutes related to the disclosure of records and information in child in need of care cases. It adds a new subsection to KSA 382212. That's the statute that identifies who can access Department for Children and Families confidential agency records. The proposed section directs the department to disclose confidential agency records of a child alleged or adjudicated to be a child in need of care to the law enforcement agency investigating the alleged or substantiated report, regardless of the disposition of the report or investigation. The information or records to be included in that disclosure to the law enforcement agency would be any information regarding that report or investigation, past reports of the child or the child's siblings and the perpetrator or the alleged perpetrator. The House Committee on Children and Seniors and then the Senate Committee on Public Health and Welfare added an amendment to add that the law enforcement agency would also receive the names and contact information of the reporter or the person's alleging abuse or neglect, and the case managers, investigators, or contracting agency employees assigned to or investigating that report. KSA 382210 is amended to include a reference to that required disclosure that's now going to be in KSA 382212E. And then it also adds an investigating law enforcement agency to the list of persons with access to the official file and the social file for those child in need of care cases. And I can take any questions.
Natalie, any concern about when that information is released to law enforcement that it would become an open record at any point?
I would not be concerned about that. The statute that comes before these statutes, KSA 382209, provides that all of these records are confidential. As you know, when you create exceptions to the Open Records Act, you guys are required to review them 5 years after you create them and decide whether you want to continue them into existence. So that exception created in 382209 was created, and then it was actually continued into existence by you all in 2014. So that exception is pretty well established at this point.
Thank you. Any other questions, committee? Thank you, Natalie. Our first proponent listed is Ed Klump.
Thank you, Mr. Chairman, committee members. My name is still Ed Klump, only this time I am here on behalf of the Kansas Sheriff's Association, the Kansas Association of Chief Police, and the Kansas Peace Officers Association. This issue that brought us to this point with this bill started many, many years ago. I have been working as a result of input from our associations for probably at least 8 to 10 years, trying to get this problem fixed of limited information that we were able to get from DCF when we're conducting a child abuse or neglect case. And we had some very serious cases where children were seriously injured or even death cases where we learned well into the investigation that DCF had additional information that we never were provided. In that length of time, I've clearly worked with several different DCF administrations. And I can tell you that I am very grateful, our association is very grateful to the current secretary who has understood our plight and has helped us to get this fixed and helped us to get to this point. So what led to this in the immediate time frame is on October 5th, I was invited to speak to the Joint Committee on Child Welfare about issues we were having with child abuse and neglect investigations. In preparation for that testimony, I had accumulated a list of issues that investigators around the state had called me about or emailed me about where they were unable to get clear information from DCF. So I took that list, I put it into a Survey Monkey survey, and just simply asked, one, that only people that were officers that were involved in these investigations would respond to it. And secondly, I asked them, have you encountered this issue in the last 12 months? I didn't want them going back into the distant future. I wanted to know what today's problems were. And there's a link in there if you want to look at the response to that. But overwhelmingly, most of them, over 50% of the investigators that responded to the survey said, yes, in the last 12 months, we have encountered this problem. I think that just showed the scope of this issue and how important it was. I don't care whether it's a child abuse or neglect investigation or any other investigation. If we can't get basic information, as basic as who made the complaint, how are we supposed to investigate it? And that's what we were confronted with in some cases. We were getting redacted reports that looked like news headlines reports coming from the federal government. You know, some pages were all blacked out. Some of them didn't even have the name of the caseworker that we could contact about the case. Key information was missing. And that's, I mean, just imagine if we were told to go respond to a robbery call and the dispatcher said, well, I'm sorry, I can't tell you who called. I can't tell you who the witnesses are, you know, just go investigate this. And that's kind of where we have been on this. And the result of this was it slowed down our investigations, which meant when there were people that needed addressed through a criminal charge, they were still out there potentially abusing this child or a sibling or somebody else. And it slowed that process down. And so that was a very critical thing for us. And I the response we got on this from that committee and the immediate response from the secretary and one of her deputies that was in that committee room was one of shock. And it should be, because this is a very important problem. So we worked with DCF over the interim to develop this bill and into the start of this session. And thanks to DCF support, we were able to come to an agreement on what needed to be done. So our position going into that is there's just a lack of clarity in current law. And here's some of the things we would hear from DCF in the past. Well, yes, this statute says you have access of free exchange of information, but we go down here to the specific statute on social files, and there's a whole list of people who can access that, but law enforcement isn't on it. You can't have that. And so those were the kind of things we were confronted. So we said, okay, what we need is we need a statute, or at least a subsection of statute, that is specifically what needs to be shared with law enforcement. There's already specific things of what we have to share back with DCF. We needed something very specific, so there wasn't all this where you go, here it says okay, but over here it may not, and over here it says no, and just clarify that. And that's what this bill provides. So if you look at the bill, on page, let me find it here. Yes, page 6, lines 2 through 13, you'll see the added language. And so it's a list of particular information there. And we felt very strongly that we needed that list, because those are the things that our investigators told us they were commonly not getting. And so the list was very important to us. Now, on the issue of confidentiality, there was actually, that was brought up by some of our members, and I asked DCF in our process of working up this bill, do we need to include that? And after discussion, we felt like, it's probably already covered in other statutes and in our operational procedures, and we didn't feel like it was necessary. But we're fine with putting that in. In fact, I was talking to the secretary before the hearing started. It doesn't hurt. This new section is what law enforcement is going to look at, see what they have access to. And it doesn't hurt to just reiterate that in this, that, hey, this is confidential information. We're not opposed to that. If you see that you need to do that, then that's fine with us. It doesn't hurt anything, and it never hurts to reinforce that. So with that, Mr. Chairman, I think that lays the background of why we're here. I can't express enough, though, how important this bill is to us this year. This is probably one of the most important bills that we've worked on this year. We have an opportunity here. We have a window here right now to fix this problem and move forward that'll help save children from abuse and neglect, help bring the right people to answer to those crimes, and just as importantly, that we can conduct a very thorough investigation. And when that person that's being accused is innocent, we can demonstrate that, and we don't have somebody falsely accused of abuse and neglect. So I'll answer questions when it's appropriate.
Any questions, Representative Carmichael?
Thank you, Mr. Chairman. Thank you, Mr. Klump. I've only been here 9 years, not as long as you, but I can remember sitting in this committee and us discussing a very prominent case in Wichita, as well as some other cases in Wichita, and I was absolutely astounded that law enforcement was not being provided this information. And I read the law myself, and I didn't understand why not. I talked to lawyers at DCF during prior administrations, and I felt like it was a Chinese fire drill, because every time I thought we were making progress, it seemed like and we never could get to a resolution. So I really want to express my appreciation to you and the association for working on this and bringing this back to us. And it's my hope and expectation we're going to hear from DCF that their lawyers have figured out that we can do this. And so I want to thank you for that. You're getting ready to say something, maybe.
I was just going to say thank you for that. However, I want to share that with the secretary back here, because we would probably not be in the position we're in today without the Secretary's support.
And I definitely recognize that because that was the predicament you and I were in a few years ago.
Absolutely.
With respect, though, however, to the confidentiality of these records, is law enforcement asking to have that additional provision put into this bill, given the fact that there already is an exemption, if you will, to the Kansas Open Records Act? Is this something you need, something you want, or is this something you're doing to accommodate concerns in the ether somewhere?
I hope the Secretary can add to my comments on that, but this is the way I see it. Open records is one thing. Open records is when people are requesting information. And as the revisor explained, there are times when the exception is optional, and there's times when they're confidential, which means we can never release it publicly. And then there's the use of the information or the exposure of that information inappropriately, which isn't an open records issue. It's an ethical and procedural issue. And so from that aspect, like I said, is it necessary? I don't know that we've ever had that problem in these cases, but does it hurt anything to reiterate that and put it right in here in the section of the statute where law enforcement is going to be going and looking to see what they have access to? I don't think it hurts anything.
Thank you, Mr. Klump. Thank you, Mr. Chair.
Any other questions? Thanks, Ed.
Thank you.
Next, we have Secretary Howard.
Thank you, Mr. Chairman. Secretary Laura Howard, Secretary for DCF. I'm pleased to be here today as a proponent of both of these bills. You know, it's such an interesting quandary that we kind of found ourselves in as we began having these conversations during the Joint Committee on Child Welfare Oversight. Because I'll be honest, I thought I had solved this issue within the agency more than a year ago when this had come to my attention in the context of a specific case. But, you know, historically, you know, KSA 382210, which you see on the first page of your bill, which speaks to freely exchanging information, it speaks to DCF, it speaks to law enforcement, it speaks to corrections. You know, I certainly read that as we should be freely exchanging information. And in the and so I certainly interpreted it that way. I expected my teams, my attorneys to interpret it that way. And in fact, I think it was in January of 2021, in response to this issue coming up internally in the agency and giving some direction to agency staff, we actually created some new forms and processes to try to ensure that information wasn't being redacted, you know, when those requests were being made and our attorneys were seeing those requests. And I think Ed already spoke to the fact that clearly that wasn't being used consistently yet. So we talked about that again during the Oversight Committee this summer. And agreed that, you know, it makes sense to ensure that this doesn't land on the interpretation of somebody sitting in my seat or a chief counsel in DCF, that we take action to specifically address the issue to do with law enforcement exchange. So we don't have people saying, well, this says free access, but under specified access, it doesn't list law enforcement, or it doesn't list law enforcement here. So we were pleased to come together with this mutually agreed upon solution. We think it addresses the situation, and certainly would be my intent all along that we should have been operating this way. So again, we are very supportive of the bill in the context of whether or not there needs to be an additional amendment related to how that information is used. Again, we don't think it's necessary, but we also don't think it hurts to put it in the same section if this committee chooses to do so, that specifically talks about law enforcement. So we don't have those very same issues about, well, it says something here and it says something else in another provision of statute. So again, we share the same goal of timely investigating child abuse, making sure people investigating that have the information that they need to determine whether or not that has taken place, keeping kids and kids safe in the state. So again, strong proponent of the legislation. I'd ask the committee's support.
You committee, any questions? Representative Carmichael?
Thank you, Mr. Chair. My vague recollection of discussions in years gone by, prior to you arriving here was that DCF lawyers were also telling me, and I may be incorrect, but I think they were telling me that there are provisions in the Code of Federal Regulations that somehow limited the dissemination of this type of information and arguably might have prevented its disclosure to law enforcement. Now, this is a big overstatement from a long time ago, but my presumption is that your lawyers have looked at this issue and that you are confident that we can do this and be within the federal regulations that your agency must abide by?
That's correct. I've also had those internal conversations, frankly, where I heard concerns from my team about what would law enforcement do with the information. And frankly, the code already addresses that in terms of further disclosure, and your revisor talked about that as well. So no, we're on the same page. My general counsel was on the same page. And so we are not concerned about any issue federally at all. This would be in concert with what laws look like in other states.
My thanks to you and your general counsel. Thank you, Mr. Chair.
Any other questions? Okay, thank you. Thank you for being here. I have written proponent testimony from the Kansas County and District Attorneys Association. Any other proponents? Any neutrals? Any opponent? Okay, closing the hearing on House Bill 2582 and Senate Bill 425. Committee, okay, let me tell you where we're at on a couple bills. I mentioned we might work 2556 today. Not quite yet, but we'll have that on the list for next time. I'm still contemplating what we do with another bill that maybe we attach to that. So kind of working through that. So House Bill 2495 I had as a possibility for today, but we still don't have an amendment, so we won't be working that one. But Senate Bill 300, I'm ready for that unless someone tells me they aren't. So I guess we'll find that out. Natalie, do you want to remind us what Senate Bill 300 is all about?
Thank you, Mr. Chairman. Senate Bill 300 would amend the Kansas Racketeer Influenced and Corrupt Organization Act, we usually just call that RICO, to add a person who has engaged in identity theft or identity fraud to the definition of a covered person, and that would also add those crimes to the definition of racketeering activity.
Any questions for Natalie? Are there any amendments? It's the pleasure of the committee. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out Senate sub for Senate Bill 300 favorably.
Is there a second? All discussion? Representative Carmichael.
Thank you, Mr. Chair. My recollection, I think, of testimony or other information that we were provided, and it was only just seemingly hours ago, was that there aren't any RICO prosecutions in Kansas. These RICO cases are prosecuted by the United States Department of Justice. And that this legislation is, in my view, unnecessary. It's supplemental to or duplicative of federal RICO law. I think we're probably doing just fine with our identity theft statutes the way they are. And if there are multinational, international conspiracies and interstate conspiracies involving racketeering and corruptly influenced organizations, that the federal government ought to be prosecuting those, is prosecuting those, has the funds and the resources to prosecute those. And I really don't know that the citizens of Kansas need to be spending their money on something that, in my judgment, is a federal responsibility, and I believe to be adequately handled there. So, yeah, we all want to get tough on identity theft, and it may make us feel good, and maybe some of us will even put it on a postcard, but not for me. Thank you, Mr. Chair.
By the way, Representative Long, I see you discussing that, and I did not say it out loud. Representative Long seconded. No, you're fine. It was my problem. Any further discussion? Representative Hoheisel, you may close.
Close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no.
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 The ayes that would like their votes recorded, Representative Hoheisel. The noes that would like their votes recorded, O'Hobson, Carmichael, Heiberger. Did I say motion carries? And motion carries. Sorry, I'm out of order today. Okay, happy birthday. It's been a long day. I'm older today than I was last time we did this. Okay. Do what? I didn't say I was old. I was older. Okay, Senate Bill 141. Natalie.
Thank you, Mr. Chairman. Senate Bill 141 would enact the Kansas Uniform Directed Trust Act.
Any questions, committee? Are there any amendments? Is there a motion concerning 141? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out SB 141 favorably.
Second, Representative Neely. Discussion? Representative Heiberger.
I just want to say that I can't wait to draft a directed trust.
This committee hearing sponsored by Heiberger Attorney at Law.
Yeah, or steal a model from someone.
Yeah, exactly, right? Okay, if there's no further discussion, Representative Hoheisel, you may close. Heard the motion, all in favor say aye. Aye. All opposed say no. Motion carries. The aye votes, Hoheisel, Carmichael, Ohabisam, Heiberger. Any no votes? Seeing none. Okay, committee, I think we're going to stop there. I gave a little thought about working one of the bills from today, but we'll wait. Give everybody a little time to chew on that. So for Monday, we have 3 bills set for hearing, I believe. I'm pretty sure it's 3. Let's put on the list a couple bills to possibly work. So let's keep on the list 2556 and 2495. And then add 2674 and 2582. Or are you raising your hands? Touchdown. It'll be fine. It'll be fine. Oh, someone else is going to have to make the motions on Monday because Representative Hoheisel will not be here. Yes, so the numbers again, 2556, 2495, 2674, and 2582. Everybody got that? Okay. Thank you. We're adjourned. Have a good weekend.